Assalamualaikum warahmatullahi wabarakatuh. My name is Radiah AQIELA binti MOHAMAD IZWAN. My matric number is 066138. So for the composition, there are two High Courts of equal jurisdiction and statutes, namely, first, the High Court in Malaya, which has its principal registry in Kuala Lumpur, and the second one is the High Court in Sabah and Sarawak, which has its principal registry at such place in the states as the Yang di-Pertuan Agong has determined. They are constituted under Article 101 Clause 1 and their jurisdiction and powers are conferred by federal law. Each High Court tries only cases that arises from its own territory, but if the parties concerned in writing, the court may try cases from territory of the other High Court. The local jurisdiction of the High Court is defined in Section 3 CGA 1964 and Section 2 Clause 1 SCA 1948. The local jurisdiction of the High Court in Malaya means the territory comprising the states and federal territories in Peninsular Malaysia, whereas the local jurisdiction of the High Court in Sabah and Sarawak means the territory comprising the states of Sabah, Sarawak and the federal territory in Labuan. In either case, the local jurisdiction includes the territorial waters and their airspaces above the states concerned. The High Court sits in key towns in each state in their respective territories. For administrative purposes, the High Court may be organized into divisions which are commercial, criminal and family. Each High Court consists of a chief judge and not fewer than 4 judges. Article 122AA provides that the number of other judges should not exceed 60 in High Court in Malaya and 13 in the High Court in Sabah and Sarawak. A judicial commissioner may be appointed under Article 122AB to either of the High Court in the same manner as a High Court judge is appointed. The judicial commissioner has the same powers and enjoys the same immunities as a judge of the High Court. And last but not least, every proceeding of the High Court, whether in its original or appellate jurisdiction, is heard and disposed of before a single judge except as provided for by any written law.
Assalamualaikum warahmatullahi wabarakatuh. My name is IFFATUL HANAN binti NORDIN and my matric number is 067549. Today, I would like to talk about the original jurisdiction of the High Court. As we all know, the jurisdiction of the High Court is established by legislation enacted by Parliament. The Courts of Judicature Act 1964 says that the High Court has unlimited original jurisdiction in both civil and criminal cases. It has the power to hear any criminal or civil case, no matter how serious, including appeals from Sessions Court and Magistrates Court. However, in several cases, the High Court's jurisdiction has been curtailed. The High Court normally only hears matters that fall outside of the jurisdiction of the other court, and most of its activity is in civil matter. In practice, it only hears matters involving sums more than 250,000 ringgit Malaysia, in comparison to the cases heard by lower courts. The number of criminal cases heard by the High Court is very little. These are crimes that are punishable by death as well as a few other extremely terrible offences. Section 23 of the Civil Procedure Act of 1964 established the High Court's comprehensive civil jurisdiction, subject to the limitations contained in Article 128 of the Constitution. The High Court shall have jurisdiction to try all civil proceedings regardless of value, where the cause of action arose, and where the defendant or one of several defendants reside or has his place of business. The fact which the proceedings are based must exist or be alleged to exist, and any land whose title is in question must be located within the local jurisdiction. The preceding section only discuss forum convenience or the correct forum in which a civil case or matter should be heard. Given numerous branches of the High Court in Peninsular Malaysia as well as the states of Sabah and Sarawak, the aforementioned factors should be taken into account prior to submitting a case. The High Court also has exclusive jurisdiction over the topic listed in Section 24 Courts of Judicature Act 1964. Without limiting the scope of Section 23, High Court shall have the same authority it had immediately before to Malaysia Day, as well as any other jurisdiction conferred on it by any written legislation in effect within its local jurisdiction. The High Court's civil jurisdiction shall encompass divorce and marital proceedings, admiralty matters, bankruptcy, and also corporations. Jurisdiction to grant probates of wills and testament and letters of administration of the estates of deceased person leaving property within the territorial jurisdiction of the court, and to alter or revoke such grants are also covered by the jurisdiction. The High Court may refer any question for inquiry or report to any special referee. The report of special referee may be adopted wholly or partially by the High Court and enforced as a decree, judgment, or order to the same effect. Civil causes or matters which cannot be tried in the Sessions Court, whether due to monetary jurisdiction or subject matter, will be tried in the High Court. For example, where the amount in dispute or the value of the subject matters exceed 1 million ringgit measure, and the subject matter of the dispute is not related to motor vehicle accidents and landlord tenants and distress. Such cause or matter falls within the civil jurisdiction of the High Court.
Hi, my name is Aishah binti SAMRAEL and my metric number is 06683. I would like to continue to talk about the original jurisdiction for the criminal cases. The general rule is that the High Court has jurisdiction over people which are citizens and non-citizens and offences committed within its territory. Section 22 of the Courts of Judicature Act 1964 provides that the High Court shall have jurisdiction to try all offences committed within its local jurisdiction, on high seas on board or any ship or any aircraft registered in Malaysia, by any citizen or any permanent resident on the high seas on board any ship or any aircraft, by any person on the high seas where the offence is piracy by the law of nations. Next, Section 22 of the Courts of Judicature Act 1964 provides that the High Court shall have jurisdiction to try any offences under Chapter 6 and 6A of the Penal Code, such as offences against state, and under any the written law specified in the schedule to the Extraterritorial Offences Act 1976, such as Official Secrets Act 1972 and Sedition Act 1, or offences under any other written law in the commission of which is certified by the Attorney General to affect the security of Malaysia committed as the case may be on the high seas on board any ship or any aircraft registered in Malaysia, by any citizen or any permanent resident on the high seas on board any ship or on any aircraft, by any citizen or any permanent resident in any place without and beyond the limits of Malaysia. The High Court may pass any sentence allowed by the law. It must be added that since offences punishable with death cannot be tried in the Session Court pursuant to Section 63 and 64 of the Subordinate Courts Act 1948, the said offence will be tried in the High Court. This is further supported by the fact that the High Court may pursuant to Section 22, Subsection 2 of the Courts of Judicature Act 1964 pass any sentence allowed by the law, and this will necessarily include death penalty. Now, let's talk about the second jurisdiction of High Court, which is appellate jurisdiction. The High Court may hear appeals from subordinate courts in both criminal and civil matters. Let's discuss first about the criminal appeal. Section 26 of Courts of Judicature Act 1964 stated that the High Court can hear appeals from subordinate courts according to any law for the time being in force within the territorial jurisdiction of the High Court. In Criminal Procedure Code stated that there are restrictions of appeal. First, cases in which no appeal lies. in Section 304 stated that no appeal shall lie from a judgment, sentence, or order of a magistrate in the case of any offence punishable with fine only not exceeding 25 ringgit. Next, when plea of guilty, limited right of appeal. Section 305, when an accused person has pleaded guilty and been convicted by a magistrate on that plea, there shall be no appeal except as to the extent or legality of the sentence. And the last one is appeal against acquittal. Section 306 stated that when an accused person has been acquitted by a magistrate, there shall be no appeal except by or with the sanction in writing of the public prosecutor. Next, for the civil appeal of appellate jurisdiction. Section 27 of Courts of Judicature Act 1964 stated that the appellate civil jurisdiction of the High Court shall consist of the hearing of appeals from subordinate courts as hereinafter provided. Section 28 of Courts of Judicature Act 1964 provides that subject to any other written law, no appeal shall lie to the High Court from a decision of a subordinate court in any civil cause or matter where the amount in dispute or the value of the subject matter is 10,000 ringgit or less, except on a question of law. In Section 28 also provide an appeal shall lie from any decision of a subordinate court in any proceeding relating to maintenance of wives or children, irrespective of the amount involved. Hence, a party may appeal on question of fact to the High Court if the value in dispute is more than 10,000 ringgit. However, if the appeal is on question of law, there is no limitation on the amount of dispute. There is also no limit on the amount on any appeal from subordinate courts or matters relating to maintenance of wives or children.
Assalamualaikum and hi. My name is NAZATUL binti KAMARUZAMAN and my metric number is 066271. Today, I will present about the third jurisdiction in the High Court, which is revisionary and supervisory jurisdiction. This jurisdiction has a power on criminal and civil proceedings in subordinate court, and its power can be seen in Section 31, 32, 33, and 35 of Court Judicature Act 1964. According to the first section, which is Section 31, it stated that High Court may revise criminal proceedings in subordinate court according to any law in force relating to criminal procedure. So, anything that is related to the criminal procedure in subordinate court may be revised in High Court. While for Section 32, it stated about civil matters where High Court may call for and examine records of any civil proceeding of subordinate court to check their correctness, legality, or suitability of decision, and also to check regularity of proceedings of such subordinate court. For Section 33, if record of civil proceeding has been called for, the High Court, with their power, may order for a new trial or otherwise as necessary to ensure justice. The last section is Section 35, where the section is about general rule on supervisory jurisdiction. This section stated that High Court shall have general supervisory jurisdiction over all subordinate court only in interest of justice, either by its own motion or on application of interested party, may call for record of any proceedings, whether in the case related to civil or criminal, in any subordinate court, which is the session and magistrate court, at any stage of proceedings, and either transfer the case to High Court or order subordinate court for further conduct of the case. Based on this section, it seems like the revisionary and supervisory jurisdiction are overlapping. However, it is not, because the intention is only to give the High Court adequate control and supervision over subordinate courts. Other than the three main jurisdictions, High Courts also have been granted with another power or another jurisdiction as according to the Section 25 Clause 2 of Court Judicature Act 1964. Actually, according to the Act, they have 17 extra powers. However, I will only present 3 powers. The first one is the sale of land, where the power to order land to be charged or mortgaged, as the case may be, in any case in which there is jurisdiction to order a sale. The second one is the discovery and interrogatories, where it has power to order discovery of facts or documents by any party or person in such manners as may be prescribed by rules of court. And lastly, other execution, where it has power to enforce a judgment of the court in any other manner which may be prescribed by any written law or rules of court.